Okay, so I'm going to talk about what are the key skills which are required from students and for being a good lawyer in for practicing in the MSME Act or for arbitration in general. So, like I said, that MSME Act is only a welfare legislation which provides a platform for all these suppliers to get interest on their delayed payments, which is 3 times the bank rate interest, and thereafter an arbitration proceeding starts wherein this benefit is given. So at the end of the day, in any kind of dispute involving micro, small, medium enterprise, if the conciliation fails between a buyer and a supplier, then arbitration takes place. Now this brings us back to the question, what are the key skills required from students and how they should consider a career in arbitration. So because the good thing about arbitration is that unlike the courts, wherein you need at least 5-7 years to learn the basics and to learn the procedure aspects and technical aspects of evidence and civil procedure code. The good thing about arbitration is that a young practitioner can make a mark in arbitration because there are no technicalities and you need not know the full CPC and Evidence Act, because Section 19 of the Arbitration and Conciliation Act makes it clear that the technicalities will not be applicable to the arbitration proceedings. And it is very flexible and party autonomy. And as a lawyer, honestly, in arbitration proceedings, face value does not make much difference. Like we see in courts that if somebody is a senior advocate, then he may be given more indulgence before the court, whereas a junior counsel may not be able to make a mark. So for young practitioners, for young students, I would always recommend that arbitration is an upcoming field. And in the words of Mr. Pali Nariman, who says that the future of arbitration is bright because the future of litigation is not. So considering all of that, we must understand that the law is pretty simple. It's not that you need to go through thousands of sections. It's not as complicated as CPC or evidence, but basics you must know about Arbitration Act and the provisions which I would recommend any student who is considering a future in arbitration or the MSME Act. MSME is a very upcoming act, and so many disputes nowadays are happening under the MSME, and many enterprises now prefer being registered with the MSME in view of the benefits which the Act gives. So there are too many arbitrations which are happening under the Act, and thus it is essential that anybody who is considering a career in arbitration may also want to be an expert in the MSME of the MSME Act. And the only thing you need to know about the MSME is the definition of a supplier or who's the buyer and what are the delayed payments and the provisions from 15 to 18, which is sufficient. If you barely read these 3-4 provisions, you know the Act. And the most important thing, the overriding effect of the Act, which is Section 24. And one thing which I would recommend is that do not be afraid of, it may appear to be intimidating and it may be daunting on the face of it, but it is extremely simple. It is extremely flexible like any other conciliation proceeding, and you must take whatever opportunity comes your way, and you must always encourage your clients or anybody you know whose payment has been delayed, and if you think they are a micro or a small enterprise, to initiate the proceedings under the MSME Act rather than initiating proceedings under the agreement which they have entered into with the other party. So that's one thing I think we all must take care of.